máa lọ court of news ẹ ní láti gbígbó ẹ̀yìn ti fẹ́ short out.
Good morning. Can you hear me?
Yes, sir, we can.
Okay. Yes. I have 277 in class now, and I've sent the YouTube link. Can you confirm whether you have received the YouTube link, class rep?
Yes, sir, I've sent it to the class.
Okay. All right. So, first and foremost, I want to say that I'm a bit uneasy taking this class this morning. Having discovered that few minutes ago that I'm to take your class today. Dr. Adibute, I think due to inadvertence, did not communicate to me that I will take your class this morning. And I already scheduled other appointments for this period. So you have to manage me if I'm uncoordinated the way I will be taking the class. I'm set actually for driving now. Well, be that as it may, I just to mention that the class, please confirm whether you are done with your conversion as a topic, total conversion, detinuing. I got a feeling yesterday from one of the classmates that you are ready to cover everything, but I confirm from the class from the lecturer, Dr. Adibute, that you have done all the topics under conversion. Please confirm to me through this medium if indeed you have covered all the subtopics under conversion. Sure.
Yes, sir.
Okay, are you done with conversion and all the topics under it?
Apparently, there are conflicting perspectives because she said she wanted to. It was like she wanted to touch it, but she did touch it. But I remember she rounded off with tutorial questions in the last class. So I want to believe she's done, sir.
Okay. So what does simply mean now is that you may need to now go on your home and read the many parts, if indeed she has not touched everything. But I believe
Hello, sir. I can't hear you.
my colleague that she has stated that in this class so that we'll be on this. The topic I'm meant to take today is trespass to land. Just a few seconds. Let me put off the other phone that is disturbing my ear. So just to confirm again that the topic I'm meant to take today is trespass to land. And so I want to believe that some of you have, most of you have done a bit of personal reading on the thought of trespass to land. And just like advice, the first intervention I had with the class by way of introduction of the tort law, I mentioned the fact that you need to go through your Kodini Anaduko. Also read through Esemalemi, and then our general Bible, which we call Wolfit and Jolly Willis, will also help you a lot. Then there's another aspect of the textbook that can assist you. That is by Graham and Stevenson. Okay, yeah, I'm sure if you read through Graham and Stevenson, you also have a general idea of what thought is all about generally. So aside from that one, you also have a lot of thought textbook written by a colleague as well, by name FC Nwoke. FC Nwoke. So if you put all these textbooks together, you will have a fair idea of what thought is all about generally. And I also mentioned that during the course of time, if time permits, or maybe during Christmas holiday, for as many of you that are interested in joining me to give you highlights on how to answer essay questions and also problem questions and what to look out for in the exams in general, we can create a link for us to discuss specifically on this area. I'm sure that will help you a lot to have a proper view of what thought is all about and of what is expected of you in the exam. And it can also assist you in other courses that you're currently doing. So I undertake to take that part, how to answer a lot of questions generally. So if you have the time, fine. If you don't have the time, that means during the holiday, you can create a time out of no time to have a mini class that will help us or that will help you to navigate through those challenges pertaining to out of other questions, because that has been the challenge over the year. Many of you are aware of the law, you understand the law very well, but in putting them together in the exam has always been a positive challenge. So now today, we are going to look at the general overview of trespass to land. And by Monday, by the grace of God, I'm going to do a deeper discussion on trespass to land. Now, just a quick start. I would say that, of course, trespass to land, otherwise known as what we call trespass houari clausum affrigates, is committed where the defendant, without lawful justification, enters upon land in the possession of the plaintiff or remains upon such land, or directly places or projects objects or any material objects upon such land. Now, you have been told during your discussion or lectures on trespass to charter that trespass has to do with interference, unlawful interference. So the same definition is true when we talk of trespass to land. It is unlawful interference on the plaintiff land. Okay. So, hello, am I audible? A class rep, confirm.
Yes, sir, you are.
All right, great. So now, having said that, you look at the word of Sir Edward Coke, who I'm sure you remember that that word of Lord of Sir Edward Coke, who says that land, according to Sir Edward Coke, comprehended in its legal significance, refers to any ground, soil, or height whatsoever. So that's his own conception of land. And so legally speaking, therefore, land includes what? The castle, houses, and other buildings. So I laid the foundation of what land is all about. Who is this person? See, we don't have time. We don't have time. I just told you. I just told you the challenge I have. I'll just call out. I'll just call out from nowhere to take this class. Please, let's give ourselves respect. If I see anyone disturbing the class, I will ask your class rep to yank you off. It's as simple as that. Please. Oluwaseyi Fakon, are you the one disturbing the class? Are you the one disturbing the class? Because I will see that you are home. Are you the one disturbing the class? Please be careful. I don't have people disturb my flow at all because it's going to draw us back. So well, or maybe I just go and read. I just go and read to this lecture. I mean, go and read this, or let me just give you the highlights. Then go and read it up if that's what you want. So a class rep, do I just give you the highlights and I have to go and read them up?
Sir, if you have the time, you can put us through. I think that would be better so that we'll know where to touch properly.
Yeah, because of this disturbance, you should know now. You should know by now. Nobody should be telling you to unmute to mute yourself. Okay, so I was saying that according to Edward Koch, that land includes or it refers to also any ground, soil, or art whatsoever. And thank God you are correctly. I think. Oh, so no, sorry. Those in 400 are the one doing land law. So when you do land law, you understand this perspective very well. And also, it says that this includes castles, houses, and other buildings. So now, interference with this interference with this uh, ownership or with this possession of this item that I've mentioned will make trespass to land. Now, if you look at the word of Blackstone's also, the Blackstone's commentaries on the law of England also says that land comprehends all things of a private substantial nature, being a word of extensive significance, which include houses and other buildings. So, look at all these things from perspective of
Hello, sir. We can't. He's gone.
Hello, class.
Hello, sir. Can you hear you?
Hello, sir. Welcome back, sir.
Yeah, so I think I had issue with okay. I had issue with internet. I don't know why I was looked at. Okay, so like I was saying, I was talking about the fact that that land itself has definitions, but I have to situate land within the context of our discussion, so that we know that when you interfere with the enjoyment of that land, then that will amount to trespass to land. So I was trying to explain, linking it with the constitutional provisions. I said, note that in defining land in Nigeria, it is all resources by virtue of the Constitution. So, some incorporated elements. Then we have some where minerals are found in the land, minerals, all these natural resources, they exclude the definition of the land in Nigeria. So, therefore, trespass to land, called trespass quarry clause vigit, is committed where the defendant, without lawful justification, enters upon land in the possession of the plaintiff. Emphasize the word possession of the plaintiffs. So we're not talking about ownership here, we're talking about possession of the plaintiff. So all remains upon such land, or directly places or project any material objects upon such land. So if you look at the foundation that I laid, I start by giving you the definition of land, so that you know that not every interference will amount to trespass to land. So now, in situating the definition that I've given to our discussion for today, which is trespass to land. Now, it is committed, trespass to land is committed without lawful justification, where the defendant enters upon the land, a possession of the plaintiff, or remains upon the land of the plaintiff or directly places or project any material object upon such land. Now, it's an inquiry to all interference with possessory rights or interest in land. So, because it comprises any intentional. So, look at the word intentional or unintentional act which directly interferes with the plaintiff's exclusive possession of land. Also, undermine the word exclusive possession of land. Now, it further defined as a wrong committed against a person who is in exclusive possession of the land trespassed on. Okay, so from this little background I've laid, I'm not talking about ownership, but I'm talking about a person in possession. What that simply means, in essence, is that even so, what that simply means, in essence, is that even the owner of a land can be found trespass on the possessory rights of a tenant. So we're going to look at this as we go on. Now, trespass to land was originally conceived as a remedy against a forcible and aggressive entry onto the land of other in the past, but was later extended to include any wrongful entry, whether forcible or not, as well as merely remaining on the land unlawfully, or even wrongfully placing a material object on it. So, therefore, trespass to land is actionable per se without proof of damage. You have been taught trespass per se. Okay, you don't need proof of damage in trespass to land. Okay, so in other words, even a hostile act can also amount to trespass to land. So, mere entry into another person's land without lawful justification will amount to trespass to land. So, as pointed out in the definition, therefore, trespass protects and is rooted in exclusive possession. Please, I'm shouting the word exclusive possession. I'm reiterating it because that is what trespass is all about. It does not concern itself with ownership rights. It has to do with possessory rights. So now the plaintiff is just a matter will not be required to prove that he has the right to or is entitled to exclusive possession. Now, considering that these torts protect possession and not ownership, the owners of land may be found liable for trespass to land. Now, for some of you that are been doing your internship in courts, especially magistrate courts, you find a situation where tenants bring landlord to court for unlawful ejection, for unlawful eviction of the property that is owned by the landlord. So the landlord is being alleged to have forcibly ejected the tenant from it. And so it's not only a criminal offense, but it's also a civil offense. It's also a civil wrong because the tenant has the right to sue the landlord for disturbing his exclusive possession, enjoyment of his possessory rights. And so that's what trespass is all about. Now, in the case of universal, who is that person? Okay. In the case of Universal Vulcanizing and ISSA United Trading and Transport Company, it was held that when a land which was trespassed on or is in the lawful and exclusive possession of another person, a suit in trespass is not maintainable by the owner of the land, who has no right to immediate possession at the time of the trespass. Please note that case, the case of Universal Vulcanizing versus ISSA United Trading and Transport Company Limited. So it was held in that case that when a land which was trespassed on or is in the lawful and exclusive possession of another person, a suit in trespass is not maintainable by the owner of the land, who has no right to immediate possession at the time of the trespass. Now, Amos Taiwo, can you hear me? Taiwo Amos, are you in class? Adekoya assistant, are you in class? Ebo Victor, are you in class?
Yes, sir. Good morning, sir.
Okay. Adekoya, can you do you have any can you interpret that point that I just mentioned now? I said in the case of Universal Vulcanizing and United Trading and Transport Company, that was held that when a land which was trespassed on is in lawful and exclusive possession of another person, a suit in trespass is not maintained by the owner of the land who has no right to immediate possession at the time of the trespass. Can you throw light on that particular holding of the court? Can you throw a little light on it?
Yes, sir. Okay, to my understanding, it just means that sometimes the owner of the land might not be the one that has the immediate possession at the time that a trespass was carried out. So if a trespass is carried out and the person that doesn't have the immediate possession can't maintain a suit for trespass, is the person that has immediate possession at the time of the trespass that can make a suit for trespass.
Okay, can you give us instance of that? The instance.
Okay.
But
for
you don't have
instance,
anyone. Okay.
No, I'm trying to put something together. For instance, if maybe a family land, for example, and the owner of the family land, like it's a family land, but the immediate possession of that land right now is in the hands of, let's say, for instance, the son of the owner.
Okay.
I don't know if that works. And then there's a trespass that occurs. It is that the son that can create a suit for trespass because he's the one that has the immediate possession at the time. I don't know if that covers it at all.
Well, no, you're also right. You're right. I was still at it from the angle of landlord and tenants. So the son, the father can claim that the son is only exercising the right on his behalf.
Yes.
So yes, but in the case of landlord and tenants matter, this like strangers contracts. Strangers contracts. So they don't have any affinity. What brought them together is money. That is a contract, possession, and the rents. So now to put what Aziza has said in proper perspective now. So in the story where landlord lives in an apartment or lives in a compound, the same compound as tenants. Okay, but the part that was trespassed on was in the possession of the tenants, and the landowner want to sue the trespasser for coming into the land, into the possession of for disturbing the possession of the tenants. So that in that case, the court says the only person that can maintain an action in that regard is tenants. Okay, I hope you got that point now. So now, in the same vein, a person who is entitled to or has the rights of possession or is in actual possession of a particular parcel of land cannot be liable for trespass on same land. So you can't be liable for trespass on your own land. That's the point we're making. If you are in possession, you are in possession at that time. Now look at the case of ISSA and Ubifuna. Don't forget that what I'm doing today is I'm giving you a general overview of trespass on land. I've not started at all. But if I'm able to cover so much today, then I think that will be it. But my duty is to run you through the meaning of a trespass to land, forms of trespass to land, and also defenses and the possible remedy. So that's what I'm going to be doing for the next 3 lectures. Okay. So now the rest easy and that case, the Supreme Court said that trespass of land consists of the selected mass or the possession of land by a person who cannot show a better to person. So myself and the I think that I've discussed. And so to acquire an own land by the Constitution. So as a result, a person is entitled to have and enjoy quiet possession of his land. And so any interference with land in the possession of another is not a trespass for land. So essentially involve direct interference, one, with land and in the possession of another person. So please note those points very well. Now also, another general rule is that trespass is usually a direct rather than a consequential interference. Please know that trespass is usually a direct rather than sequential interference with other person's land. What that simply means that trespass to a person's land are often in the form of a nuisance. Class, do you get that point very well? I just want to answer me. You get it well. I said, we're talking about direct interference. So, and I said as a general rule, trespass is usually direct rather than a consequential interference. A consequential an indirect interference. So if it is direct interference, then that could mean a nuisance. So you're going to be taught nuisance, I think, second semester. Okay. So, but just to mention that any direct trespass to a person's land are often in the form of a nuisance. This is especially private nuisance. And the action is usually the thought of a nuisance. Why any when you are your second semester, you are doing the news topic. I'm sure as well as the ethic and the because private property issue answer me is what? Any invasion of private property, be it so minute, is what? Hello?
Sorry, sir.
Someone said my notice
Yes.
is breaking. Are you sure it's breaking? But I can hear you. I can hear you very well.
Yes, sir. Your network is breaking terribly.
Okay, so you can't hear me well?
Yes, we can hear you, sir.
Wow. But I've
We
been
barely
asking.
hear you, sir.
Wow. But I can hear you clearly. What is the issue? I can hear you clearly. I don't know.
Oh, yeah, so, we didn't get what you said before.
All right. But okay. I said that in the case of antique and carrying, do you get that point? In the case of antique and carrying, I said it was either every invasion of private property, be it so minute, is what? So I want the class to help me complete it. That every invasion of private property, be it so minute, is what?
Interference. Trespass.
That means it's a trespass. Good. So please know that case very well as you go on. Now, apart from entry into land, anything done that interferes with a person's rights to possession amounts to trespass. So the lack of motive on the part of the trespasser will not initiate an action for trespass. So, and that's why we say the court has said that be it so minute, any interference with the land or of another or is trespass. So motive is irrelevant in this kind of thoughts. So it will not be a difference that it was trespassing or that he understood that the property belonged to him, or that he did not know that by entering into the land he would be interfering with the rights of another person. So motive is relevant in this thought. Now, also in the case of Basley and the Clarkson, Basley and Clarkson. Now, the defendant was moving his lawn, L-A-W-N, like lawn tennis, lawn, when he innocently and unintentionally entered into his adjoining neighbor's land by mistake. And he cut the grass thinking it was his on his land. He tendered some money in satisfaction of the interference. At the suit of the plaintiff for trespass and damages, the court held that the defendant had committed trespass to land and mistake was not a defense at all. So, just to let you know the length, even despite the fact that the man was innocent or that he committed a trespass to land by honest mistake, the court still held that it was not a defense. Even he tendered money to placate the interest of the person in possession, and the court said it was not enough. So know that when a person abuses the purpose of which he has been permitted to be on the land as well, he has become a trespasser ab initio. So you are going to see the case of Balogun and Alakija as you go on. You are going to see the case of Harrison and Duke of Rutland. You are going to also see the case of Hickman and Macy. All these cases point to the fact that when a person abuses the purpose for which he has been permitted to be on the land, it becomes a trespasser ab initio. You are going to look at the trespass ab initio as you go on. So where your initial entry was right, your initial entry was lawful, but at the point the person in possession decided to let you off his property, decide to let you off his property and give you an instruction to leave his premises, and you stay over, and you hold forth on the person's property, you become a trespasser, despite the fact that your initial entry was lawful. So that's trespass ab initio. We look at all these things also as we go on. Now, where right to enter is abuse, it may be trespass in ab initio. Now, in the case of Harrison and Duke of Rutland, is a good example of what I'm talking about. The plaintiff entered the defendant's land and interrupted the grouse shooting party. So its entry was held to be a trespass to land. Also in Hickman and Macy, the defendants were making notes on the highway of the form of the race horses being tried out on an adjoining land. Because that the rest of marks on the highway was another trespass. The proper use of the highway is for passing and the passing. It's for passing and the passing. So when you are now making that mark inscription you see on the highway were made lawfully by the owner or by the government. But when individual now go on the highway and start marking the highway without lawful justification, then that will amount to trespass to land. I'm exposing you to special breeds of the trespass to land, so that when you see problems in the exam, you're able to situate your answers within the confine of what we are saying. Now, so once the plaintiff is able to establish that the defendant unlawfully entered into his land, or that while on the land he did things which was outside that which was lawful for him to do, he will be entitled to damages, even though he has suffered no loss or injury. We say it's actionable per se, so he'll be held liable. You may be allowed entry, but if you start to do something on the property that was outside what you are allowed to do, that also amount to trespass to land. Now, trespass can be committed in so many ways. I'll give you the forms of trespass. Enters upon land of the plaintiff, that is in the presence of the plaintiff, also remains upon land of the plaintiff, then also directly places or projects any material object upon such land. Those are the forms. Now, trespass may be committed in so many ways, but a space above the land to extent reasonable for user. I'm sure you have read part of the element of thought that you have been introduced to in your first or second class will be that trespass can be committed on land through the airspace. So airspace above the land to extent reasonable for user. I'm sure you have read the Civil Aviation Act. You see some of the exceptions to that. The earth surface or land surface. You know that whoever owns the land owns anything beneath and above the land. So these are also indications of trespass that can be committed. So that beneath the earth surface or the ground so by tunneling or mining of mineral resources, this can amount to trespass when you tunnel the underground or surface of the places possession. This can amount to trespass and so on and so forth. There are many of them. In the case of airspace trespass, now trespass to the airspace above. You look at the case of Kersin and the Imperial Tobacco Company Limited. Also look at the case of Baskin and the Skyviews and General Limited. You also look at the case of the case of Olanino and Fatoki, Oladiko and NGSB. So we are going to look at all these cases as we go on. But just by way of general review, I want you to, on your home, look at these cases I have mentioned. TORTS is a case-based tort. And so you need to equip yourself with as many as possible as you can. Okay. But before the exam, rest assured that I, for one, will come to class and give you will give you some cases that will guide your reading. But for now, master all the cases that I mentioned. Don't wait for exam period. Now, so in cases case, for example, an advertisement signboard fixed by the defendant's company on an adjacent premises projected into the plaintiff's airspace. A few feet signboard into his airspace. Now, the court held that was trespass. You know why? Because the invasion of the airspace by the advertising sign was a trespass. So the plaintiff was entitled to an injunction for its removal. Even though the act complained of resulted in no harm, because he held that he was entitled to injunction for its removal. Okay, so in Baskin's case as well against Scavius and General Limited, the defendant's company was taking aerial photographs from above 650 feet in the air, crossing the plaintiff's land in the air. In order to do so, the plaintiff claimed damages for trespass to his airspace and for invasion of his privacy. If I remember very well, Graphic J held that the defendants were not liable. You know why? Because an owner at common law had the right above his land to source height in the sky as was reasonably necessary for the ordinary use and enjoyment of the land and structure on it. So you look at the 6 feet. 6 feet. Is he high or is he lower? You're going to look at that when we read that when we read that particular case. Then, so the key point to note here is that liability does not arise in respect of flights which are at reasonable height in the air and which comply with statutory requirements. For example, the requirement of the Civil Aviation Act. However, liability in trespass or nuisance may arise from other lawful activity carried on. So it does not mean that because there's no trespass in there, there's no liability in trespass, that there will not be liability in other area of thought. That's one interesting thing about thoughts. And that's why when you're asking your exam, be careful. Do not go outside the scope of the question. I could recall in second semester, those currently in foreign level, you ask question in the rule in rather than pleasure. Because rather than pleasure, to some extent, you have some aspects that has to do with or that are similar to nuisance. Some of them went to town and started discussing nuisance for pages. And the question and the marking scheme says rather than pleasure. So if you now go and discuss trespass nuisance and all that, you're going to lose almost 70% of the mark, because it will mean that you are not mastering the principle of law discussed in class. So the fact that liability in trespass may not arise. Does not mean that you cannot maintain an action in nuisance. So, note down very well. Liability in trespass or nuisance may arise from other wrongful activities carried out. For example, deliberate emission of smoke that pollute the place of land is not trespass, or may not be a trespass, or may be a nuisance. So depending on the fact of the case. So they also know that exclusive possession in trespass to land means actual or constructive possession. So mere physical presence or mere usage of control of land does not translate to possession. Okay, so a servant in a house cannot sue for trespass, neither can a visitor on the premises sue. So you have to know who and who have the possessory rights over a particular property or over a particular premises before you can maintain an action in trespass to land. So mere physical presence or usage of control of land does not translate to possession. Servants, your mates may not be able to sue in trespass to land. Also, your visitor or premises may not be able to sue in trespass to land against a trespasser. It's only the person who's entitled to possession that can sue in trespass to land. So now, a person cannot bring an action on the basis of de facto possession, because now the plaintiff will not be able to bring an action for trespass that occurred before he got into possession of the land. So trespass committed before your entry, before your lawful entry to the premises is not maintainable by you. However, a person who is entitled to some interest on the land will be able to sue for trespass or intervened by the trespasser. So we are going to look at all these instances as we go on. Trespass to land is a very interesting topic, and though it's straightforward, but at times it's technical. So, and that's why I want to focus so much on this area of law. Then after you should look at the case of Olaniyan and Patoki, look at Oladipo and the NGSB. So then let's look at examples of trespass to land. Okay, now in general, I've given you the forms of trespass to land. Okay, but with specificity, some of them include the slightest entry of land. Don't forget, I said without lawful justification. The slightest entry of land. You ask yourself, was the person authorized? Was the trespass justified? So, slightest entry of land is trespass. Okay, leaning on the fence of a land, leaning on the fence of land is a trespass. Refusing to leave and remaining on land after permission is revoked is a trespass. Class, am I audible?
Yes, sir. Yes, sir.
Okay, all right. Great. So now, leaning on the fence of a land is a trespass. Refusing to leave and remaining on land after permission is revoked is trespass. Balogun and Alakija is clear on that. Putting anything on land or projecting anything above land is also a trespass. Projecting it on the land is a trespass. Walking on or crossing another person's land is a trespass. Sitting on another person's wall is also a trespass. Can you see all these daily occurrences that we do on a daily basis? You have been told, you have been warned that these are trespass acts. So from today on, desist to avoid being exposed to litigation. Then you also have using a private landed property as a shortcut to get to another person's place is also a trespass. Driving animals into another person's land is also a trespass. You know, if you're a nomad, you should understand this point very well. If you're a nomad, understand this point very well. Then throwing refuse or anything to another person's land is also a trespass. That's when you project any material object upon the land of another person is a trespass. So as well, so projecting any object into the soil of another person's land or immediate airspace is a trespass. I'll give you the case of Ethic and the Carnity. So every violation of private property, be so minute, is a trespass, though there be no damage. So then also in Mark V and the person's names unknown. Some persons whose identity were unknown moved into the plaintiff's property and started squatting there. The plaintiff brought an action for trespass to eject them. The court held that there was trespass. So squatters, you won. Squatters, you can be sued in trespass to land. Okay. Now, if you ask your seniors, those in foreign level or those on our way to law school, I think the only class I did not teach taught them was this foreign level. So if you ask them, they will tell you that in every class I take, I clearly distill the elements of a particular thought. And so the purpose of having the elements, Andy, is that it will guide you by the time you are writing your exam to know how do I couch my question around these elements. The question being asked or the scenario being given, is it on this particular element? If it's that particular element, then that will amount to that particular thoughts. So the element of trespass to land are not far-fetched from what you can find in your code and Aluko, what you can find in your Yellow Wish and Winfrey and Yellow Wish, or what you can find in your Graham Stevenson, is that there is or was a direct entry on the land. You ask yourself, the scenario given to me, was there a direct entry on the land? Okay. Was the defendant remaining on the land? Did you remain on the land? Did you place or project any objects on or above the land? These are crucial elements to look out for in the thought of the trespass to land. So, I said, you ask yourself that, was there direct entry on the land? Did he remain on the land after the initial termination of his entry? Did he remain on the land? Did he place or project objects on or above the land of the plaintiff? These are the things that you have to look out for. Then two, that the plaintiff has possession or right to immediate possession of the land. So you must also find out that the plaintiff has possession or right to immediate possession of the land. Okay. So then, lastly, that the entry is without lawful justification. The entry is without lawful justification. Please note these three elements very well, and you can form your notes using the various forms of trespass in these elements I've given you. Now, so for trespass by wrongful entry, we said enters upon such land in the possession of the plaintiff without justification. So, as always, facing up his hand. Bolu, Olwadamilare.
Yes, sir.
Oh, okay, you
I
have the floor.
wanted to ask a quick question, sir.
Okay.
When we are talking about trespass, I think the part where, under the case of Bernstein and Skyview and General Limited, I wanted to ask, this is festive season, and a lot of people are interested in fireworks. This is festive season, sir, and a lot of people are interested in fireworks. So if maybe somebody does fireworks and then it travels up into the air, but it does not exactly it's not in maybe a straight projection and it trespasses onto another person's land, does that amount to trespass?
Yeah. First of all, I want to ask: is that my own Bolu?
Is that my own Bolu? So,
sir.
I don't think so, sir.
Okay. Well, so yes, that's a very brilliant question, but that that Yuletide celebration is not an excuse. It's not an excuse in thoughts. That's how we say liability. So the point here is lawful justification? Is there any lawful justification? Can you say that because you want to celebrate Christmas or you want to celebrate the season, and not give you justification to interfere with another person's property? Certainly no. Certainly no. So that will amount to trespass. Okay, so depending on the circumstance of the case. Now, always ask yourself, was that act lawful? In other words, was there any lawful justification? Okay, say you want to see the permission. In some neighborhood, in this season that we have, it's a season that people need to tolerate. But again, not everybody believe in Christmas celebration. Are you aware? Are you aware?
Yes, I'm aware
Yes.
of that. Yes, sir.
Yes. So not everybody believe in Christmas. In fact, not everybody believe in a New Year celebration. I know of Jehovah's Witness. I have a friend with a Jehovah's Witness. He does not believe in Xmas celebration. In fact, he found that there was no basis for that. So if you not trespass on that person's land through your fireworks, because you are celebrating, you can sue to court and tell the court that that is not part of his own religion belief. Muslims don't believe in Christmas celebration because there's no basis for birthday celebration. So, but everything has to do with belief. Faith is about faith. January 1 celebration, some people don't believe in this because they believe that every day is special. So there's no special thing that about January 1. And that is what also brings joy to many people. That is the time they unwind, they meet their friends, family and friends, and all that, and they do the fireworks. And so even there are rules as to even fireworks as well. So we throw fireworks indiscriminately in this part of the world. Okay, if you go to abroad, it's not, you can't just go on the street and be spraying fireworks. You can't just so. I think that answer that part. Of course, we are coming back to this area very as we go on. But today, for those that are in class today, I'm
I
sure.
also have a question.
Okay. Oh, is that Gabriela?
Yes, sir.
Okay. Is it Gabriela? Professor Chimba's friend? Okay, Gabriela that presented won the seminar in class one day. Where do you want?
No.
Okay.
Gabriel, sir.
Okay. All right. Go ahead.
Okay, so I actually wanted to ask questions since so my hand has been up since. I'm going to take you back to the Band 80, basically, and Claxton case that you mentioned when you were telling us, when you were introducing us to trespass to land. Yes. And the fact of the case was that, the defendant mistakenly mowed the lawn or cut the grass of the plaintiff. However, he tendered some money which was, satisfactory according to at least the case.
Yes.
And the court still held him liable. Like before the suit, he had paid, okay, he was like, oh, I'm sorry for this, so this is my payment, my compensation for this. And why then did the court still find him, liable? Yes. That means we still have to pay money again. Isn't that what it means? Why?
Yes. Oh, brilliant. So, I'm happy you mentioned the fact. I'm happy you have read the fact of that case. So, the purpose of dissuading people is an attempt to dissuade people from committing trespass. Now, the fact that you have approached me with even money that's surplus, right? I use the word surplus carefully because to let you know that if you give me a lot of money that out of assuage me or my feelings, if I have a discretion to either accept or not to accept, it cannot be a defense. Why the court refuse, or why the court held that there was trespass in that case was that it is not enough, or it is not enough to say that so it's not enough to say that I offered him money. You can offer me, if you like, offer me your house, your property. That cannot stop you from suing in courts. Don't forget, some people sue for deliberate reason. Now you are seeing the person's name now,
maybe for posterity, that person's name is accidental law report for life. That will be the reason for suing. Now, I was in court one day when I was practicing in Ibadan as a lawyer. I was talking about the 2011, 2012. I was in court one day when someone sued Skybank. I can mention Skybank now because they are moribund. So he sued Skybank just for 17 naira. He said they deducted 17 naira from his accounts. You know, all the charges, they do that to you, they do that to me, they do that to everyone. Okay, if you aggregate all these monies together, and they have begged this man to withdraw the suit in courts so they can pay him the 17 naira and also pay him compensation. He said no. So he wanted the court to make a statement. He wanted to make a statement to the courts that you cannot be deducting people's money illegally. And so when the court inquire into what do you want, since they say they want to settle, he said it's about money. He was a rich man. So what am I saying is that everyone, the claimant or plaintiff, has his own reason for suing. And so what the court needs to do is to make pronouncement as to the propriety or otherwise of the acts of the defendants. So the court erred in that case because that there was trespass because there was indeed a trespass. So you know why I started that case was I was talking about motive is relevant. Mistake is relevant. So what the question is that was there lawful justification? If the answer is yes, then there'll be trespass.
Thank
Grace.
you, sir. Sir, wait.
Grace, Unachi. Grace,
Yes,
are you
sir.
on?
Yes,
Grace,
I'm here, sir.
are you the one of Dr. Lax?
Yes, I am the one, sir.
I asked Bolu to ask you to meet me in the office. I don't know why. Yes, but I said Bolu to you that I should meet me in the office.
Oh, I didn't know that, sir.
Okay, no problem.
I'll meet you later, sir. But sir, I have a question concerning.
Go ahead.
All right. So my question is, I've noticed that from most of the examples we've given concerning trespass, is people that are committing this trespass. But what if, for example, maybe one of your neighbors has a pet or an animal, and the animal trespasses like into your property? Can you then hold the owner of the animal for trespass to land or trespass to property?
Now, that's another brilliant question. Yes. Now, don't forget that you are using the word person. Look at the definition. It says it's committed where the defendants. Okay. Now, in second semester, you're going to be looking. You're going to be discussing liability for animal. Okay. You're going to be looking at the street liability. The street liability as a TORTS. So, that's what I'm saying, that every particular act in TORTS has its own heading. So now the fact that you cannot sue for an animal that trespass on animal that trespass on the property of another, that does not mean that you cannot sue in another TORTS. But just to answer your question, look at this particular element. To project any material object. Now, because the question will be asked, if the straining of animal to the land of the plaintiff is due to your incitement. Look at the word. Is due to your incitement. You are the one inciting that animal. That can be equated to projecting. That can be equated to projecting an object. An object in this instance could mean whatever that is in your care as a defendant. But ordinarily, this example that you gave is better treated under street liability for animal, because you have a duty to ensure that the animal you take does not stray to your neighbor's land. once it is tree, it amounts to street liability, but not in trespass to land, but it amounts to street liability as a tort. So that's what I can say for now. But you are going to be seeing some examples. I'll be giving you when we start properly on the issue of projection of material to the land of the plaintiff. Who is that again? Gabriela, you are still on?
Yes, sir. I want to ask another question.
Oh, okay. Please be fast so I can maximize this. I said I want to run just one or 2 points before we call it today.
Okay, thank you, sir.
Well, yes.
So with regards to this issue of interference with airspace, if in
Yes.
a case, and I understand what you know, what you
sorry,
mean, but
Gabriela, I'm coming. Gabriela, please note that I shouldn't keep quiet on this, but let me just because I love your class. Gabriela, or the class, please note that example. Note the question that Grace asked. I would love to lump that question. I would love to lump it in your exam question. But since she has brought it out, note that point very well. Okay, go ahead, class. Go ahead, Gabriela.
Okay, thank you, sir. So as I was saying, with regards to the interference with airspace, if for instance,
airspace, okay, all right.
Airspace. If for instance now, like there are two neighbors, and one of the neighbors was growing a tree, and initially the tree was just in the neighbor's compound, but as the years went by, the branches of the tree enlarged towards the airspace of the other neighbor's compound. Could that be regarded as an interference with airspace?
Now, if you read the case of entity can carry it very well. Every property, be it ever so minute, is that one not minute, Gabriela?
Yes, sir. Yes, sir.
It's minute, so it's a trespass, and that's why I mentioned the fact that even leaning on the wall, just to lean on someone's wall. Now, don't forget that I don't know if some of you have seen. Oh, you know the housing law for those in foreign level. Okay. For some of your classmates who are in some people who are in foreign level, but they're still taking thought. They should understand better that when you look at the tenancy agreement or whatever, you will see that they will say an appurtenances. The apartment you are renting come with appurtenances. So if you have common area, no co-tenant can claim that someone has trespassed. You have a common area. There's property that you have common area of use. Maybe like TV, all and all that. So nobody can claim trespass there. But in your own personal apartments, leaning on that person's wall amount to trespass. So look at the example I've given. Okay, when the person enters another person's land, such as by walking on the person's land, you find that in entering and carrying, loitering, sitting, driving, or by other means, it commits trespass to land. So unless there's a lawful justification. So lawful justification will be interpreted based on the circumstance and fact of the case. So it is not a defense at all for a trespass to land, for a trespasser to plead that he entered it in the honest or by mistaken belief that it was still part of his own boundary.
But you said that trespass to land must be direct. This is not direct. He didn't know that initially the branches did not extend to the other person's compound. When he was growing the tree, he was in his own compound. But maybe in 5 years' time, it's been extended to the person's compound.
The question you asked was that the person was cutting was falling tree, Abi. Is it?
No, that's not what I said, sir. I said the person was growing a tree. The person grew a tree in his own compound, and the tree was in his compound, gongon, and it's not extended to his neighbor's compound. But as the years went by, as the tree started growing branches and everything, maybe in 5 years' time, the branches of the tree now
Okay,
extended to the neighbors.
The branches of the branches of
extended to the neighbors' compound.
No, that's not a trespass to land. That can be at best nuisance. Hello?
Okay.
Yes.
Yes, sir.
Okay. I didn't get you well. Okay, so yes, of course. Now, of course, that's a consequential act. That's an indirect act. Yes. That's a trespass. That could be at best a nuisance, because when you know the meaning of nuisance is an act that annoys, that irritates. So there's no particular case on that under nuisance. Who again? I think we have exhausted the okay. Ugochukwu Paul.
Yes, sir. Good morning, sir.
Okay, good morning. You have a question?
Yes, sir.
I can handle, because we have like 5 or 10 minutes to go.
Okay, sir. I wanted to ask. You said that there was a case you mentioned earlier in class, that someone was taking photographs from an airplane, and you said that the defendant was found not liable because the airplane was like high up in the sky.
Yes. Have you read Civil Aviation Act?
No, sir.
No, you did. Oh, what's the semester? I don't know. What's the semester they are going to on the topic on? Okay. I think it's still under trespass to land. Don't worry, we are going to discuss that, because it's like a mini topic on its own. We're going to discuss that next week, so that we'll not waste our time. We'll not be repeating ourselves.
Okay.
You see, the law sets certain limits, okay, as to what will amount to trespass for something above the land. The thought of trespass to land has to do with qui plantato solo sedits. Whoever owns the land owns anything beneath and above the land. Now, then, in fact, that same expression also finds its way through the word, the Latin maxim known as cuius est tolu, and a very long Latin maxim, which when we get there, we'll discuss it. So there are certain limitations to trespass to land when it comes to airspace. So we call it trespass above and below the surface of land. So we'll discuss that. And it's based on the maxim of cuius est tolu, ius est square at the column east and iveros. So that whoever owns or possesses the surface of land also owns or possesses everything above the heaven, above it to the heaven, and also everything below it to the center of the earth. So, and the Civil Aviation Act has provided some form of a limitation by saying that no action shall lie in relation to trespass or nuisance by reason only of or of the height above the ground, which is reasonably having regard to the wind, weather, or so. There are a lot of limitations that we're going to look at when we discuss trespass above and below the surface of land. But next week we will reach to that level if time permits. Okay, so now, so by next week we are going to look at that, and also trespass ab initio. Okay, I mentioned before that trespass ab initio means trespass from the beginning. Okay, so under law, certain persons have the right to enter premises in the course of the lawful discharge of their duties. So example of these people are the police. The police can enter your house. Will you call them trespassers if they enter your house to control some cells or to do their lawful duty? No.
Yes.
So who is that? Someone say yes. Who is going to say yes? Please justify now. You say yes. Umoba, are you the one? Are you the one? Okay, Sammy.
Sir.
Okay, you have any justification for that? I said a police cannot be liable for carrying unlawful discharge of their duties. I said no.
I wanted to ask a question.
Okay, go ahead.
Yeah, good morning, sir.
Yeah, money.
It is true that, let's say, a trustee can bring an action for trespass, to land. So I want to know if a beneficiary, in a way, can be held liable for, the trespass to land.
No, that can be liable. No, a beneficiary of the can be liable.
Yes, the beneficiary. If the trust can bring full action with respect to trespass, so can the beneficiary be held liable for trespass?
You can. You know why? Because we said someone that has possession right or immediate possession, or someone that has immediate right to possession. Now, as trust, because you need to ask yourself, as trustee confer interest in the land to the beneficiary. Hello, Steve, I'm asking you. So you have to look at it from the angle as the trustee confer the interest in land to the beneficiary. Don't forget that in trust, the testator entrusts the land to the trustee. So trustee does transfer to beneficiary. So until that is done, the beneficiary cannot come over the land and say, I'm the owner of the land. No. So except the trustee is unduly prolonging. And so when you do under the trust law, you understand all this thing better. There are instances where the trustee may not want to yield possession to the beneficiary. Okay, and that's why the trust law came to protect the interests of beneficiaries. Okay, so it's a very deep concept. Not so you can do this over within one class. But just to say that the fact of the case will determine whether it can maintain an action or not. Okay, if he has been told, he has been well informed that he has a reversionary interest on the property, and nobody's allowed to, and nobody's ready to protect that interest. Of course, he can, but where trustee is in charge of that property, the president cannot, because we're talking about possession here, not ownership. So I think that explains that for now. So like I was saying, the police officer, postmaster, okay, the PSN officials and so on and so forth. Firemen, they have the right to enter your property, and that would be a defense to them. Okay, but however, where the permits has expired and they still enter the property, they can be charged or they can be liable in trespass. So the doctrine of trespass ab initio means that when the person enters the landed property of another person by authority of law, which is distinct from permission granted by a plaintiff, and the person subsequently misbehaves or abuses his right of entry by stealing, damaging, destroying, assaulting, breaching of the peace, and so on, the plaintiff can maintain an action against them, and their trespass will be treated as if they have no authority at all to even enter the property at the beginning. So that's one of the implications of trespass ab initio. Okay, where someone has been granted lawful entry, whether by law or by the permit given by the plaintiff himself or herself, and they abuse their particular privilege by stealing on the property, destroying, damaging, or does an act that is inconsistent with the possession right of the plaintiff, then the plaintiff can maintain an action against them through trespass ab initio, and their entry will be treated from the beginning as if they had no permit or they had no authority to enter the property from or ab initio or from the beginning. So that is what we call trespass ab initio. Okay, so exception to trespass ab initio is that where the authority by license, by license, permission, or invitation to enter was made by the person to a defendant, or trespass, the doctrine of trespass ab initio does not apply. This is because the defendant entered wrongfully as an invitee, license, or upon an invitation to treat. So, you can read this six capital case, okay, on this point. You can read six capital case on this point, okay. So I think we have 6 minutes to go, so that my student who will be waiting for housing law in the next 5 minutes can join. I think today we are okay for now. So by next week, by the grace of God, we are going to start the topic very well. So I've done the overview of trespass to land today, and I want to say congratulations for those that were in class today. So we have indeed benefited from the discussion, even despite the fact that I'm in an uncoordinated area and also unprepared for the class. But I want to believe that we have not done badly. Our class, your feedback. Have you done badly today?
No, sir. But I have a question, sir.
Okay, go ahead. Go ahead, please.
So is it you can get your materials?
Right. That's what I'm saying. You know, I said from the beginning that I didn't pay for this. I didn't pay for this. I just packed somewhere. They quickly work on the or taking the class. So I'm not even. I didn't pay for this class at all. I'm just using my student knowledge for you.
Oh, thank you very much, sir.
Yes. No
question.
Yes. No problem.
Sir.
Yes.
So I have a question.
Yes,
Okay,
sir.
go ahead.
Okay, so I want to know if bringing an action against a tortfeasor is the only option available to the owner of the trespass property. Can the owner of the trespass property also use reasonable force? For example, maybe someone makes it an habit. Maybe someone makes it an habit to always urinate in front of the house of the owner, in front of the house or the gate, and the owner doesn't like it. Can the owner use reasonable force by let me say pouring water on the person just to stop the person from coming? Or let me give another instance. Some people are always fond of spreading clothes on the fence of their neighbors. And what if the clothes mistakenly falls into the compound and the owner of the house refuses to allow them to take their clothes? Can it be seen as reasonable force of going too far?
Thank you. Is that Jayi? Is that Jayi?
No, this is Abi.
Okay, Abi. You know, one of the remedies, we are going to discuss remedies. One of the remedies in trespass to land is self-help. Okay? Self-help. So self-help is allowed. Okay, but it has its own limitations. So we'll discuss that. Okay? So that's what the remedies are. Aside from in fact, there are many remedies in trespass to land. You have action for Type 2 and recovery of land, order for recovery of possession. So you have damages. So damages is not even the major one, but you know, damages is a general remedy for torts. So you also have injunction. You have a lot of injunction, distress, claim of made profits, putting up a notice, warning trespasser to keep off. There are a lot of remedies that we're going to look at. It's a very interesting topic. Honestly, it's very interesting. And we cannot. If you look at textbooks generally, it appears so small. I mean, the discussion, but it's not. You can't exhaust the discussion on trespass to land. You can't. Okay, we'll just be
Sir.
streaming it. Yes. Yes.
Yes, sir. I need you to clarify something for me. So, when you are giving the examples of how trespass to land can be committed, you said putting anything on land or projecting anything above the land. You also said throwing refuse or anything on another person's land. So I want to know what's now the line between trespass to land and nuisance. Because of it looks like nuisance to me because of it's indirect. Like throwing refuse on someone's land is indirect.
But when someone asked a question, I think I can't remember the person asked question anymore. About maybe is it branches of a tree moving to but I can't remember the question again, but I know it has to be related, and I was able to clarify that. See, if you look at those thoughts, there are thin lines. There are thin lines at times between trespass to land and nuisance, because when you trespass over someone's land, you are not the person to some extent. I know we say it's an art that irritates. So that's nuisance. But because we are not doing nuisance in first semester, so you may to understand that major difference between the two. But what the law says is that when you project any material, when you are throwing something to someone's land, you are projecting material objects. And that's what I'm saying. Get the definition and the element. Once you understand the element of every thought, you don't have any problem at all. In fact, you'll not be confused in the exam. So understand the elements, the forms of a particular thought. It will set you free. Okay, so for now, because housing law is this 11 o'clock. The housing law commence now. Okay, so class, I wish you all the best. We'll meet by the grace of God next week, Monday.
Sir, good morning, sir.
I have a question.